Rules Committee, come to order, and thank you very much for joining us this beautiful day. Today, as we come back, we'll be considering H.R. 2152, the Citizens' Right to Know Act of 2017, H.R. 5645, the Standard Merger and Acquisition Reviews through Equal Rules Act of 2018, and S.J. Res. 57, providing for congressional disapproval under Chapter 8 of Title 5, United States Code of the Rules, submitted by the Bureau on Consumer Financial Protection related to the indirect auto lending in compliance with the Equal Credit Opportunity Act. Mr. Chairman, you are used to these words every day, and I'm getting used to them. H.R. 2152 requires jurisdictions that receive grant money from the Department of Justice to operate a pre-trial release program with federal dollars. To report to the Attorney General certain information concerning the defendants, including criminal histories and numbers of times the defendant has failed to appear in court. The preliminary duty of the federal government is to keep citizens safe. This legislation ensures that taxpayer dollars are not used to allow hardened, violent criminals to return to the streets as they await trial. American citizens deserve to know what types of defendants are being released in their communities prior to trial. The committee will also consider H.R. 5645 legislation that ensures companies face the same standards and processes regardless of whether the Federal Trade Commission or the Department of Justice reviews a proposed merger. Under existing law, both the FTC and DOJ may review proposed mergers and negotiations and acquisitions. However, the two antitrust agencies face different standards in court and utilize different processes when reviewing these transactions. Transparent, consistent standards by antitrust enforcement agencies, I think, will help enable a more stable economy and a fair process. The Rules Committee will also consider a joint resolution to repeal the Consumer Financial Protection Bureau's 2013 guidance on indirect auto leasing. Even though the Dodd-Frank regulatory law prohibits the CFPB from overseeing auto dealers, the Bureau has attempted to monitor and control third-party lenders. This regulation has allowed the CFPB to claim jurisdiction over the $1.1 trillion auto finance market without any public input or statutory legislation. S.J. Res. 57 uses the Congressional Review Act to overturn the guidance and block the CFPB from taking similar action. Without objection, I'd like to welcome the gentleman from Texas, the gentleman from Dallas, Texas, Chairman Jeb Hinchley, as well as the gentleman from Illinois, Congressman Foster. We welcome both of you to our first panel. Anything you have in writing will be entered in the record without objection. I look forward to your testimony. However, before we go there, we're going to yield to the distinguished gentleman from Massachusetts, ranking member of the committee, for any opening statement you'd like to make. Gentleman's
well, thank you, Mr.
Yes,
Chairman. I guess it will come as no surprise to you that I'm a little disappointed to see what the Republican leadership has prioritized here today. We have a lot of major issues facing our country, matters that the American people overwhelmingly want us to discuss, but here we are, yet again ignoring those big issues. You know, I was just home in my district, like all of you were, but I went to a parade. I participated in a walk for hunger. I went to an open house at a fire station in Leicester, Massachusetts. I went to an event to celebrate the success of our regional airport in Worcester. I visited a senior center in Millbury. I met with home builders. I met today with Honduran and Salvadoran TPS holders who are, quite frankly, who have been here for over 20 years legally and are very nervous and upset that the administration has basically taken away their protections and wondering what we're going to do. I had countless coffee and breakfast meetings with constituents, and there was one thing in common, one thing, and that is not one person asked me about any of the topics that we're going to be considering here today. I didn't hear about the Citizens' Right to Know Act, and I can promise you that if I did a poll of my constituents, none of them would guess it was about pretrial services. No one asked me about mergers and acquisitions. None of my constituents asked me when Congress was going to attack another Consumer Financial Protection Bureau action aimed at helping people. They asked me about a whole bunch of other things, but none of these made the list. And so it's a little bit frustrating. We could instead maybe be talking about a bipartisan farm bill, but we're not going to be able to do that because the process in the Agriculture Committee to get us a farm bill was anything but bipartisan. In fact, it was the most partisan process I have ever seen, occur in the Agriculture Committee. But I want to talk about that process because I did write you a letter, Mr. Chairman. As you know, I also sit on the Agriculture Committee, and I saw a comment from Chairman Conway recently made. It was an extraordinary claim about the Farm Bill. He said that he expects the committee to adopt a rule, he expects this committee to adopt a rule that would basically amount to a loyalty pledge to the Republican leadership. He said that if members want to offer amendments to the Farm Bill, they must first agree to vote for the bill. I mean, usually sometimes you don't ever decide whether you're going to vote for a bill until after the amendment process. And I think I've never, I mean, this is a sort of process I think that might make even Donald Trump blush. And it certainly would be a break from tradition of this committee. And so that's why I wrote you a letter. And we received your reply last week. I want to thank you for writing me back. But I was disappointed that you didn't really address Chairman Conway's comments. I asked unanimous consent to insert both those letters in the record. I guess that means without objection. Mr. Chairman, I was a little bit troubled by the language you used on the you referred to so-called poison pill amendments, which basically suggests that any ideas that Republican leaders don't like can be labeled as poison pills designed to bring that bill down. And I take it that that means that that Democrats shouldn't even bother to participate in the amendment process. You did write in your letter that you would be, quote, facilitating a robust and open debate on the House floor, end quote. That sounds like an open rule to me, but since we've had no open rules in this Congress, or had no open rules under Speaker Ryan at all, I don't expect that that's what you meant. But I raise this issue because I think this process is really reaching a level that should concern not just people like me, but should be of concern to a lot of Republicans as well. We all represent the same number of constituents. And, this Rules Committee ought to be a place where people who have good ideas, whether you agree with them or not, who have legitimate ideas, ought to be able to have an opportunity to be able to offer them. And increasingly, we're moving away from that. And I was alarmed by Chairman Conway's letter because it seems to reinforce that, but yet to even a different degree, where he basically said if you're not going to pledge to vote for the bill on final passage, you don't have a right to offer amendments. And I appreciate you writing me back, but it didn't calm my concerns or my fears, and so we're frustrated by the process. We're frustrated that a lot of the big issues that people talk to all of us about when we go home, and I'm sure they're talking to you about them as well, don't ever seem to make it to the House floor. And while I appreciate my two colleagues for being here, I will tell them that what they're here to talk about today was not brought up once. Well, in any event, I hope that that in the future that the leadership on this committee will more forcefully reject any idea or any notion that somehow we need to take loyalty pledges before amendments can be considered, because I think that would be a very, very bad road to go down. And again, I hope if we're lucky enough to take over this place, I hope that we're more accommodating on some of these matters. Certainly, Chairman Conway was not at all accommodating on the Agriculture Committee. I'll just close with this. Believe it or not, I'm the ranking member on the Nutrition Subcommittee. And you all know I talk a lot about hunger and food insecurity quite a bit. We had 23 hearings on the nutrition title in the Ag Committee. 23 hearings, and the language that appears in the nutrition title was not reflective of any one of those hearings. In fact, I couldn't find anybody on the committee who wrote that language. Nobody knew where the language came from. The Ag Committee has historically been probably one of the most, if not the most, bipartisan committees in the Congress. And yet there's an entire title, and I can't even get any majority staff to tell me who wrote the language. I've never, ever experienced anything like that. I mean, I think if you're on a committee, you ought to have some say in what the language is. And certainly if I were in the majority, I would want to make sure that we wrote the language. But in any event, it's a terrible process. I don't know when the Farm Bill is going to be coming up here, but I'm really disturbed by what Chairman Conaway has requested, and I hope that you, Mr. Chairman, will reject any suggestion that we need to take loyalty tests before amendments be made in order. So I thank you for letting me vent, and I yield back my time.
Thank you very much, Mr. Gunn. Without objection, anything that you had asked to be put in the record would be put in the record, and I appreciate that very much. The facts of the case are pretty simple. You did send me a letter, and I did respond back, and while I was not privy to hearing it said perhaps the way that Chairman Conaway evidently alluded.
Yeah, he made it public I was reacting to an article in which he said those things. So that,
yeah, once again, I was not privy to that, but I'm not trying to challenge that at all. My point is that it's pretty easy to before a game to say what you're going to expect and what you're going to do. At no point did Mr. Conaway, did he direct that to me. And at no point did he say, well, here's exactly what will happen. As you know, and I know, you had an opportunity. You talked about amendments at the committee. Evidently, you chose not to, the Democrats chose not to offer any amendments to the bill.
we did, Mr. Chairman, if the gentleman would yield, we did because, I mean, we didn't know any of where the language came from. Yeah. It just appeared out of thin air, and I've never really had that experience before, quite like that, especially after 23 hearings on a particular title. But in any event, I mean, we can argue about the substance of the bill later. I was just concerned about the chairman's public remarks that we will have a rule that basically says, unless you pledge to support the bill on final passage, we will not entertain your amendments. And he's not on this committee, and that's why I wrote you out of concern. And I hope that that maybe privately or you know, in your Republican conference, that you will make it clear that that's not the way we do business up here. But that's the way we should do business up here.
Well, as you know, I do not recall any time since I have been on, or at least as chairman, where anybody specifically said, if you, on our side, if we're going to give you an amendment, are you going to vote for the bill?
Now, this was the first time I saw anybody say that, so I was a little bit startled.
That's why it was not.
So I didn't know if this.
Mr. Sir, Mr. McGovern, I think you're entitled to write the letter, and I tried to write back and tell you that, look, I have tried to make this committee very open, where people are encouraged to come, where we accommodate people till all hours of the day and night, and your side is here too, and having to do those things, and we've encouraged members to be here. So,
if I may, just one final thing.
Yes, sir.
And that is, my final point is that, you know, it seems that this kind of, you know, attitude where we try to accommodate as many viewpoints as possible so they could be fairly heard on the House floor seems to be something of the past. And I'm worried about a total breakdown of any bipartisanship. And I just will say this, the Agriculture Committee has probably been the most bipartisan committee in this Congress. And Colin Peterson, who is the ranking member, probably one of the most conservative Democrats that we have, if not the most conservative Democrat in Congress, if you can't strike a bipartisan deal with Colin Peterson, you can't strike a bipartisan deal with anybody. And so, I mean, this is a guy who, you know, who wants to work in a constructive and bipartisan way, and all that bipartisanship broke down. And I think it's just sad, not only for the Agriculture Committee, for the institution. And anyway, I raised that because I had never heard anybody on your side put it quite so bluntly before, and it raised a lot of concerns. And I thank the gentleman for his letter, and I yield back and look forward to hearing our witnesses.
Gentleman yields back his time. Thank you very much. And the other member that would like to be heard on the subject, seeing none, we will now move.
Good. What you referred to actually happens fairly often in the Science Committee. It's just an interesting observation.
Thank you very much. That is a member, and he has an opinion, and Bill, we appreciate you expressing your opinion about the way you think you see things. That's, Mr. Chairman, that's part of what we do up here. We handle a lot of things that are important to the body and a lot of things that are very consistent with what your committee does and others. We're delighted that you're here. As the gentleman knows, this is an important day for the committee to hear things about rules and regulations. I had an opportunity also as I was back home to hear things, and Don Herring Jr., a gentleman that you know, contacted me personally about the bill that we're going to do today, and several other car dealers expressing their opinion about what we're going to do, and 2 consumers actually contacted me. So I, unlike Mr. McGovern, did hear from people back in Dallas, Texas about these things and a number of other matters. So I will say I had a chance in Dallas to hear from consumers who want to make sure that they receive the benefit of less regulatory burden. So, Mr. Chairman, we're delighted that you're here. The gentleman's recognized.
Thank you, Chairman Sessions and Ranking Member McGovern, members of the Rules Committee. Thank you for the opportunity to testify today on S.J. Res. 57, a bill which uses the Congressional Review Act authority to nullify the Bureau of Consumer Financial Protection's March 2013 bulletin relating to indirect auto lending and compliance with the ECOA. S.J. Res. 57, introduced by Senator Moran of Kansas and co-sponsored by 24 of his senatorial colleagues, passed the Senate with bipartisan support just 3 weeks ago. The Congressional Review Act, or CRA, provides Congress with the opportunity to review any major rule by a federal agency before that rule goes into effect, as this committee well knows. By affording Congress the opportunity to review major rules, we ensure that the executive branch of government is indeed held accountable to we the people through their elected representatives. When the Bureau issued its March 23 bulletin under the guise of guidance, it attempted to skirt legal obligations to Congress and the American people and further expand an already uncountable agency's jurisdiction to an industry that the Dodd-Frank Act statutorily prohibited the Bureau from touching. Indeed, again, let me repeat, the Dodd-Frank Act prohibits the Bureau from regulating auto dealers. Simply put, the Bureau was de facto promulgating rules that have a drastic impact on the economy, all while going out of its way to avoid the notice and comment requirements of the Administrative Procedure Act. If Congress means what it says when it writes laws, then the Bureau should not be allowed to willfully ignore that law and deny market participants due process in the offing. The concerns with this bulletin are not partisan, nor are they limited to the House. Last Congress, more than 90 members of the House and Senate, both Democrats and Republicans, sent 13 different letters to the Bureau asking questions about the methodology it employed to determine whether fair lending violations exist in the vehicle finance market. These letters also expressed serious concerns regarding the Bureau's bulletin. Furthermore, Mr. Chairman, in November of 2015, the House passed with a veto-proof margin by 332 to 96 a bill to repeal this guidance and require any future rulemaking efforts to be subject to public notice and comment. While our Senate counterparts did not act then, they have thankfully acted now. Using guidance as a mechanism for enforcement is not only wrong, but in this case appears to be an attempt to change industry practices in the guise of guidance. In the white paper ultimately provided by the Bureau outlining their efforts, the Bureau admitted that its proxy methodology for determining racial disparities was flawed and overestimated the number of African Americans impacted by 20%. However, research by the well-respected Charles River Associates found that this figure could be off by as much as twice that number, 41% to be specific. Not only does the Bureau's action call into question the reliability of its methodology, if it was allowed to continue as planned, the Bureau's action would actually have increased cost for many consumers. In other words, Mr. Chairman, it would be anti-consumer. The Wall Street Journal found in an analysis that interest payments for some consumers could increase by as much as $586 over the life of the loan. And Mr. Chairman, as you well know, from a lot of good folks in Dallas and in East Texas, that's a lot of money. That's $586. That would be an increased burden for Americans like Katie from Virginia, who was in desperate need of a car as her husband, Richard, could no longer work due to a prolonged illness. Thanks to our dealer's efforts on her behalf, she was able to get a low-mileage car with a factory warranty. And according to her own testimony, she now, quote, has solid, reliable transportation and a payment that she can easily afford, unquote. Or we must also remember Haley, who worked at Dunkin' Donuts and had very little credit due to her young age. She was able to get financing through her local dealer for a car, which now, quote, allows her to look for a different job which pays a higher hourly wage, unquote. Kind of the American way, Mr. Chairman. To my colleagues on both sides of the aisle, I ask, shouldn't we stand up for hardworking Americans in need of auto financing like Kathy and Haley, who need a car to get to work or take care of a sick family member? Shouldn't we also stand up for the rule of law and due process? If not us, then who will ensure that the federal government, regardless of who sits in the Oval Office, is indeed accountable to the American people? Mr. Chairman, I thank you, as always, for the opportunity to testify before the Rules Committee. Happy to answer your questions.
Mr. Chairman, thank you very much. Mr. Foster, working with the Rules Committee, the gentleman is recognized.
Well, thank you, Chairman Sessions, Ranking Member McGovern, and the other members of the committee. I'm here to testify in opposition to S.J. Res. 57. S.J. Res. 57 provides the congressional disapproval of guidance on discrimination in the indirect auto lending industry. So what's going on here? You know, I'm a scientist, and it's one of my constant frustrations is that you seldom get chances to do controlled experiments. Here is something you can. They have something that's called testing, where they send in two consumers, one white, one non-white, and they look at their experience in a variety of industries. And I guess it's sad but not too surprising that the results are often very different. That estimates are that if you're non-white, you spend anywhere between about $250 to $2,500 more as the total purchase price of your car. Simply, that is the cost of being non-white in our country, according to controlled experiments where they use non-whites that have credit ratings and incomes often better than the white reference control, the control consumers. So the scientific data here is not ambiguous. It is a fact that minorities are far too often discriminated, whether the loan application is approved or whether the rate is charged on the loan. This guidance is important to protecting American consumers. In the past, critics of the CFPB guidance have argued that it relies on data that's inaccurate or misunderstood. A 20% error, we're not talking about a small effect. We're talking about a very large extra price that minorities are charged in the total purchase price of cars and other goods. And so this is not a small effect, and even a 20% discrepancy between one or two studies here does not change the qualitative observation that there's a massive injustice going on here. The bill that the majority is bringing to the floor this week will preclude the reissuance of this guidance, which is instructive of how to actually comply with the Equal Credit Opportunity Act of 1974, which will remain in force. I should say. The lenders will rightly still be required to comply with the law, leading to at least what one analyst called S.J. Res. 57 a long-term negative for lenders, because they're going to have uncertainty. They're going to say, look, we still have to follow the law on fair lending, but since we're going through the auto dealers effectively as loan brokers on this thing, who knows what the law will really end up being. The CFPB was trying to provide clarity on this by issuing the guidance to saying here's where the dividing line is going to be here. It's also, so it's bad for consumers and ultimately bad for lenders. It's also, unfortunately, become an ideological vehicle that's intended to thwart the filibuster rule in the Senate. That's why it's coming down in the way it is. And its consideration is occurring long after the 60-day window to disapprove of a rule through a construct that I don't have time to go into here. But this is unfortunately consistent with the way the House has been run for most, perhaps all of the 115th Congress. Instead of debating a bill that could have attracted bipartisan votes in this chamber as well as the Senate, SJ 57 is an attempt to limit the ability of the CFPB to ever provide instructive guidance on complying with laws that are meant to prevent discriminations. Some critics of the CFPB guidance have argued the exclusion of auto dealers from CFPB jurisdiction limits the ability of the Consumer Bureau to promulgate guidance on fair lending in the auto industry. However, the entity-based exclusion of auto dealers from CFPB oversight does not erode the authority of the CFPB to issue product-based guidelines regarding discrimination on the loans that these financial services entities are issue, and so it puts it squarely within their jurisdiction. What's going on here is that if an auto dealer overcharges a non-white person, the extra profits from overcharging them is shared between the auto dealer and the banks. And what the banks are trying to do, and the loan originators here, not originators, the loan, the people who are taking over these loans, what they're doing is attempting to capture the profits from discriminatory practices without taking the responsibility to make sure that that the people acting on their behalf in the auto dealer showrooms are not acting fairly. Anyway, both experience and empiricism makes it crystal clear that the need for guidance to increase compliance with anti-discrimination laws is clear. I urge the committee to oppose consideration of SJ Res 57 and to oppose the rollback of the guidance intended to curtail discrimination, which unfortunately remains very real. Thank you.
Mr. Foster, thank you very much. Chairman Henserling, the gentleman and you both alluded to Dodd-Frank, where the law in Dodd-Frank, the words said that specifically this sort of work by CFPB would not be allowed. But the gentleman's arguing that there's this widespread discrimination, and I didn't hear who his subject was that talked about how the validity of this, but why did Senator Dodd and Mr. Frank not ask, why did they specifically state that they would not get in here if this evidently...
Yeah, if you look at the roll call in committee, they both voted against this was the Campbell Amendment, I believe, that was offered to Dodd-Frank that had bipartisan support. I think it's widely viewed as a mistake, certainly among Democrats, when you look at the fact that it has not resulted in a disappearance of discriminatory practices in loan issuance.
Mr. Chairman?
Yes, sir.
Well, number one, you would find scant Republicans who supported Dodd-Frank in the first place. So this was at a time when the Democrat Party enjoyed super majorities. So the only way it could have been put into law is that a majority, significant Democratic support for this particular provision, regardless of how it got in there. It's the law of the land, Mr. Chairman. Whether it is wise, whether it is unwise, it is the law of the land, and it should be respected, and the Bureau did not respect it. Another point I'd like to make, Mr. Chairman, I respect our scientist's dedication to science, but the science he has alluded to does not exist. The Bureau could not produce it. And instead, it is illegal for auto dealers to actually collect racial data. And so instead, what the Bureau did was they made educated guesses. They looked at people's surname, they looked at their zip code, and then they decided themselves whether or not somebody was a member of a racial minority. And so, again, we don't even have good science to determine. Third point I'd like to make is when it comes to the Equal Opportunity Credit Act, if this particular SJ Res is passed, all the prudential regulators still have full authority to enforce ECOA. They still have this ability, and in fact, the Bureau will still retain the ability, except not to impose it on a class that they legally cannot impose it on, particularly when they are using junk science. And by the way, Mr. Chairman, if anybody wants to conduct the experiment, I would ask them to simply Google auto finance on their smartphone, and there will be a plethora of companies that come up. This is a convenience that many auto dealers offer so you can get your financing at the same place you buy your auto. There is a very competitive market in auto finance. No one is forced, as either a legal matter or a practical matter, to get their financing at the dealership where they buy their car. And indeed, there are dealers who manage to do wholesale deals with lending agencies, and then they sell that credit on a retail basis. And every single auto buyer has the ability to go and to take that to the market and decide whether or not this is good, whether it is not good. And the lender doesn't even can't know what the racial characteristics ultimately of that borrower is. So for so many different reasons, it is just compelling that the House pass this CRA.
Yeah, thank you very much.
Yeah, I'd just like to say in defense of the science here, I'd like to enter into the record a document called, generated by the National Fair Housing Alliance, entitled Discrimination When Buying a Car. It describes data that was taken over the last couple of years. The subtitle is How the Color of Your Skin Can Affect Your Car Shopping Experience. They did what I referred to. They put side-by-side consumers with where the non-white person had a better credit rating, often better incomes and so on, and guess what? You did not have comparable results in this. And so this is, it would be nice if the statistics were infinite. There certainly could be 20% errors, but the effects that they saw were not small, and I believe that they were not unrepresentative, unfortunately, of what's happening in many areas of this country.
Chairman Cole? No questions. Mr. McGovern?
Thank you, Mr. I share Mr. Foster's concerns, and I have no questions.
Gentleman does not have any questions. The distinguished gentleman from Alabama.
I have a question, Mr. Chairman.
Gentleman does not seek time. Gentlemen, is there any other member of the committee that would seek time for two witnesses? Ms. Forrest?
Yeah. How would this resolution impact the buy here, pay here model?
You're going to have to be, if you're asking me the question, yes. I need greater specificity. The buy here?
Mm-hmm. There are traditional car dealerships that are, good business people who are just trying to assist a buyer purchase their home. And then there are those bad actors that prey on people who may not have the best credit available to them. And there is a model called buy here, pay here, where you buy the car from a dealership and you make payments to the dealership. Oftentimes it is advertised as you only have to pay $99. In the contract, you have to read the contract, small print, to understand that it's not $99 a month, it's maybe $99 a week. They put a device on the vehicle, a tracking device, so they know exactly where the vehicle owner is. And if you're a day late in making your payment, then your car is repossessed. So how is this new resolution going to impact that model?
To the best of my knowledge, the original CFPB guidance only dealt with the wholesale funding model, which is not the model you describe as I understand it. So to the best of my knowledge, it would not impact it. But I admittedly have not studied the model, but the original CFPB had to do with wholesale lending to retail auto dealers.
If that is the case, then I have to express my concern that we have a closed rule and we're not addressing an issue that is a really big issue in my community with the buy here, pay here models, to the extent that when I was in the state legislature, we took up legislation on this issue. The other problem that I also see that hasn't been addressed and can't be addressed in a close rule is an issue of, yes, auto financing can be done by the dealership, and if you're buying an ad vehicle, for example, it's a deeply discounted price for an ad vehicle. It's the Sunday ad. But if you want that price for that vehicle, then you have to agree to the terms of financing with that auto dealership, which could be up to 2 points higher than financing that you can get from either your financial institution or your credit union. It is unfortunate that we are not addressing the real issues of the working class in my community in a close rule as this bill is moving forward. Mr. Chairman, I yield back.
Thank you. Ms. Torres, I don't intend to do anything other than offer some explanation. This rule is either what you're going to do is say that the CFPB is not in that business, or you oppose it and believe they should be in the business. We're not really amending anything other than, we're not amending anything that they've done. It's that Dodd-Frank says that they shall not be in that line. CFPB shall not be. So this is just saying, do you think they should be in the business or do you think they shouldn't? We're not really amending anything else, certainly not any of the rules or regulations. It's simply saying we do not believe that they should be as I guess I'd call a line of business within their jurisdiction. This is not within their jurisdiction. We're not really amending anything that they're thinking, saying, or doing. We're simply saying you have no, you may not offer rules in that business.
Will you yield back? So how would it impact third-party lending?
Well, what it says is the CFPB is not authorized to have rules related to this auto lending business.
So third-party lending, it's my understanding that this resolution would overturn the CFPB's bulletin relating to third-party auto financing and prevents the CFPB from issuing new guidelines.
Yeah, it's, if
Is
I
that correct?
may, yes, it's
Right.
it's my understanding that this thing primarily is related to racial disparities in this, and what you referred to was an abusive business practice, sounded like an abusive business practice, which is not necessarily racially based. And so I think that it's my guess that probably there is not an objection to that business practice based on the national laws having to do with banks discriminating in their lending.
Indirect auto lending and compliance with the Equal Credit Opportunity Act is specifically as I read this. But this is not amending necessarily any section of that. We're not opening this title up. We're simply saying you may not be in that line of business. Thank you. Does anybody want to disagree? Thank you. Mr. Buck, Mrs. Cheney, thank you very much. Gentlemen, thank you very much for being here. We appreciate the time. Now, just so you know, Mr. Foster, while we did take testimony and mention to the awesome stenographer your words, if you would like to enter anything into the record that would be specifically a report, we will hold this open for 5 days for you to enter that and would then engage that. So without objection, that would be entered to the record if it's provided within five business days. Thank you very much. Mr. Chairman, thank you very much. Is there any other member that would seek to be heard on S.J. Res 57, S.J. Res 57? Seeing none, this now closes the hearing portion of SJ Res 57. We would now, as previously announced, open up testimony. The gentleman, Mr. Marino, appeared a few minutes ago, and we would ask the clerk, Ms. Booth, to please go ahead and have Ms. Marino welcome. We're delighted that you're here. Mr. Cicilline is expected to appear, and by golly, there he is. Oh, he's got a big old smile on his face, so he is here. David, if I could get you to please come up here to the table. Gentlemen, previously we have announced to the committee and discussed Citizens' Right to Know Act of 2018 and Standard Merger and Acquisitions Review through Equal Rules Act of 2018. We're delighted that both of you are here. Without objection, anything you brought in writing will be entered the record. The gentleman from Pennsylvania 10 is recognized. Mr. Marino.
Thank you, Chairman Sessions, for the opportunity to testify today regarding H.R. 5645, the Standard Merger and Acquisition Reviews through Equal Rules Act, or the SMARTER Act. In 1914, Congress passed the Federal Trade Commission Act, marking the beginning of a dual antitrust enforcement regime in the United States. Because both Department of Justice and the Federal Trade Commission enforce our nation's antitrust laws, companies may, and often do, have different experiences when interacting with one agency relative to the other. One area in which the disparity can be the most striking and troubling is in the merger review process. When a company wishes to merge with or purchase another company, it must notify both antitrust enforcement agencies of the proposed transaction. DOJ and the FTC then determine which agency will be responsible for reviewing the transaction. As there are no fixed rules for making this determination, it can appear that the decision is made on the basis of a flip of a coin. There are two substantial differences that companies face based on the identity of the antitrust enforcement agency that reviews the company's proposed transaction. The first difference arises in the agency seeks to prevent the transaction by pursuing a preliminary injunction in federal court. A different legal standard is applied to a preliminary injunction request dependent solely on the identity of the requesting antitrust enforcement agency. The second difference lies in the process available to each antitrust enforcement agency to prevent a transaction from proceeding. The FTC may pursue administrative litigation against a proposed transaction even after a court denies its preliminary injunction request. In contrast, DOJ cannot pursue administrative litigation. There is no justification for these disparities in the merger review process and standards. The Bipartisan Antitrust Modernization Commission recommended that Congress remove the disparities, and the bill before the committee, the SMARTER Act, does just that. This important legislation will enhance the transparency, predictability, and credibility of the antitrust merger review process. By enacting the SMARTER Act into law, Congress will ensure that companies no longer will be subjected to fundamentally different processes and standards based on the flip of a coin. Notably, the legislation has garnered the support of former and current FTC commissioners, including former Chairman David Clayton, former Commissioner Josh Wright, and current Commissioner Maureen Olhausen. In fact, the mergers amendment planned to be offered makes technical and clarifying changes suggested by the FTC itself. The SMARTER Act is an important step toward achieving these committee's goals of assuring that our nation's antitrust laws are enforced in a manner that is fair, consistent, and predictable. Thank you for the opportunity to testify in support of it. And
thank you very much. Ms. Cicilline, welcome.
Thank you, Mr. Chairman, members of the Rules Committee. It's wonderful to be with you, Chairman Sessions and Ranking Member McGovern. I appear before you today in opposition to H.R. 5645, the SMARTER Act, and H.R. 2152, the Citizens' Right to Know Act. I think you only want me to speak to the SMART Act at this point, right?
Yes.
Okay.
Either one. As you do speak, please tell us that you're speaking either about HR 2152,
Yes.
Citizens' Right to Know, and then as you choose to end that, then or 5645.
Great. HR.
I'm
sorry.
I didn't speak to.
You did not.
Do you want to go? I'm happy to.
2152. I thought we were going to wait and do it separately.
We'd ask you to do it all at one time. Yes, sir.
Okay. Thank you to my friend. Okay. Turning to HR 2152, the Citizens' Right to Know Act. This bill requires jurisdictions that receive grant money from the Department of Justice to operate a pretrial release program to report to the Attorney General certain information concerning the defendants. The bill requires the jurisdiction to submit the criminal histories of the defendants and the number of times the defendant has failed to appear as ordered by the court. It also requires the Attorney General to make public the information the Department of Justice receives. This bill is beneficial because citizens have the right to know what types of defendants are being released into their communities prior to their trial. If defendants have a long history of criminal behavior or frequent failure to appear in court, the community should know that. Likewise, residents should be aware if their community is running a successful pretrial service program. Simply put, no matter what side of the bail or no bail debate you find yourself on, you should support this bill. Information like this in the hands of the public is never a bad thing. It will also be helpful to those of us who make policy on these matters. Thank you, and I'm happy to answer any questions. And I hand the microphone over to my colleague.
Thank you very much. Continuing as we would choose, the gentleman's recognized.
Thank you, Mr. Chairman. I appear today before the Rules Committee in opposition to H.R. 5645, the Smarter Act, and H.R. 2152, the Citizens' Right to Know Act. I have significant concerns with both of these bills. H.R. 5645, the so-called Smarter Act, is an attack on the FTC's ability to vigorously promote competition by eliminating the use administrative litigation and merger enforcement, an important component of the commission's structure. Over a century ago, Congress responded to waves of consolidation by creating the Federal Trade Commission to promote, develop, and protect competition and the antitrust laws. There's long-standing bipartisan consensus that the Commission's use of administrative litigation to address anti-competitive mergers and conduct is core to this mission. For example, former Republican FTC Chairman Bill Kavasiak has raised concerns with the Smarter Act because administrative litigation has been critical to addressing anti-competitive mergers and conduct, including mergers that would have raised Americans' cost of health care. Former FTC Chairwoman Edith Ramirez has similarly argued that this proposal, and I quote, risks eroding a fundamental institutional attribute of the FTC, authority Congress very deliberately granted to the FTC when the agency was created to serve as a complement to enforcement by DOJ, end quote. What's more, this extreme measure does not solve an actual problem. In the most comprehensive study of administrative litigation to date, Republican FTC Commissioner Maureen Olhausen debunked procedural concerns with administrative litigation as mostly anecdotal or theoretical, concluding it has been a transformative tool for advancing competition policy. That's why we should be deeply skeptical about due process claims made in support of this bill. But even more importantly, we cannot retreat from antitrust enforcement. We are witnessing historic levels of concentration and market power across the economy. These concentrated economic power is undermining economic opportunity and widening inequality by raising consumers' costs, depressing workers' wages, and eroding private sector investment and innovation. Hardworking Americans want lower prices, more and better services, and better wages, and we need more competition, not less. So instead of undermining antitrust enforcement on the basis of purely speculative harms, as H.R. 5645 would do, we should give the antitrust agencies the resources and tools they need to enforce the law. I also have deep concerns with H.R. 2152, the Citizens' Right to Know. This bill would require a state or local government that uses Justice Department funding to pay for a pretrial services program to report annually certain information on the department about defendants who participate in the program. While I believe that the consideration of the issues underlying this bill is timely, this legislation is unfortunately misguided. The requirements in this bill largely mirror legislative initiatives being advanced by the American Legislative Exchange Council, or ALEC, under the false guise of transparency. This group has helped facilitate the passage of nearly identical legislation in states such as Florida and Texas, designed to displace pretrial service programs by imposing administrative burdens upon them. Citizens have the right to know what their government is doing. However, I question whether the categories of information that must be reported under the bill are adequately designed to educate the public about how the government works or about the efficacy of these programs. In addition, although the Judiciary Committee adopted an amendment I offered to eliminate the reporting of arrest records of participating defendants, H.R. 2152 continues to raise privacy concerns. The bill requires that reported information be made publicly available by the Attorney General. The American Civil Liberties Unions expressed concerns about this publication requirement and the harms to individuals resulting from the sharing of their criminal records and personally identifying information. Individuals participating in a pretrial service program have not been convicted of a crime. I see no need to compile and publish information about prior convictions and the failures to appear in connection with identifiable specific defendants. This would be unnecessary and unproductive. I understand that amendments have been submitted to this committee to address some of these concerns and also to encourage states to eliminate monetary bail. I hope these will be made in order so that we may engage in a full discussion of these issues during floor consideration. But I also hope that the House will soon take steps to do something about the real problem, our nation's unjust money bail system. We're in dire need of legislation to encourage states to end the practice of requiring money bail, a practice that disproportionately impacts the poor and the most vulnerable in our society. And that's why I'm a co-sponsor of H.R. 1473, the No Money Bail Act, which would reduce Justice Department grant awards to states that do not eliminate money bail and would also eliminate bail at the federal level. Instead of considering H.R. 2152 today, we should be advancing legislation such as H.R. 1473. And with that, I thank the chairman and look forward to any questions on these two proposals.
Mr. Cicilline, thank you very much.
Thank you, Mr.
I don't
Chairman.
spend a lot of time in the courtroom, but we were talking about really here the risk of not appearing in court, as I understand it. That's what this question's about. And yet, it seemingly took on another bent, which I don't doubt happens, and that is people don't have money and they sit in jail. Is that right?
Poor people who don't have money sit in jail. That's right.
Whether you were going to appear or not appear wasn't the issue.
That's
Do you
correct.
have any money?
That's right.
And you believe is that addressed at all in this, or you're saying that's where we really should go?
I'm saying that's where we really should go. There's
That's what I
legislation
heard
to
you
address
say.
it. Yeah, absolutely.
Because that's an entirely different issue. And I do confess I see that. I've seen that. I've heard about it. I know it exists, where there is somebody that simply cannot put together money. And I think jurisdictions are coming to a prescriptive viewpoint that violent criminals we need to keep in and others we don't. And so probably these jurisdictions recognize it as not really worth their time to do that. So I felt like that the economies of cities and the cost was driving lots of these jurisdictions to reconsider it. So be interested in seeing that.
Yeah.
I try and stay up with this, but have no actual facts that I could bring forward here. But I believe you are correct. Thank you very much.
Thank you.
Excuse me. Chairman Cole.
Make it work, folks, just to say
I need to start.
questions.
I need to. He choked me up.
But I have none, so you'll back.
The gentleman has no questions. Thank you very much, gentleman. Mr. McGovern.
Yeah, I don't have any questions. You weren't here in the beginning, but I don't mean to offend you, but I was just home for the week like all of you were, but nobody talked about any of these bills to me. These issues weren't brought up, but you guys are on the Judiciary Committee, and you know, I just met with a group of Hondurans and Salvadorans who have been here legally under TPS for the last 2 decades, and whose protections have been taken away from them, who are anxious about what their future is going to be. I would encourage you to maybe at some point get your committee to do something about that. And then in addition, I mean, we've had millions of young people across this country protest the rise in gun violence and the massacres that occur on a regular basis in this country. Whether you agree with their point of view or not, I mean, your committee is the one that was responsible for bringing those things to the floor. I just think, you know, there are people who are concerned about some of these things, and then we get this. And so, anyway, I don't have any questions, but I would just encourage you to go back and tell the chairman of the committee that there are some other issues out there that people are, not just in my district, but all across the country, clamoring for us to take action on, and we're not. I yield to the gentleman.
If I may, I agree with the ranking member, and be assured that on every occasion that we can, even during the discussion of issues like the two bills before the Rules Committee, we raise with the chairman our frustration, the Democrats, that issues of immigration reform, the DREAM Act, responding to the plague of gun violence in our country, and a range of other issues ought to be the subject of the Judiciary Committee hearings. As you know, the chairman decides what bills we consider, but I will be happy to communicate back to him that there is additional support from some members of the Rules Committee to start addressing the urgent issues facing
and again,
the
I'm not saying that, I mean, I obviously know that the majority disagrees with most of what I think, but I think what my constituents have a tough time understanding is why we can't get anything to the floor to even debate. And, you know, people who feel like me can have their opportunity to make their case. People who feel differently can make their case. But some of these issues, you know, have been, you know, front and center in public opinion, and the frustration is not even about how we decide them. It's just we're not even considering them. And so, anyway, I thank you for being here. I yield back.
Thank you very much, gentleman. Yields back his time. Distinguished gentleman from Louisville, Texas, does not seek time. Gentleman from West Palm Beach, Florida, Judge Hastings.
Mr. Chairman, I'm sure that both our witnesses are familiar with the United States Department of Justice's Bureau of Justice Statistics, their 2016 report on jail inmates. And I don't even know where to begin to try to get people to understand the dynamics of two people commit the same offense. One is out, and the other is in because he or she is poor and can't afford it. The other person goes to work the next day and is with their family. The other person loses his or her job and is not with their family. It doesn't take much to understand that there needs to be significant change. I'm not a fan of an organization called the American Legislative Exchange Council, but I do know that they support this particular legislation and are representing the industry that has a compelling interest in this particular matter. If I could be personal, one of my best friends is a bail bondsman. I never thought I would need his services, and fortunately did not. But I have had a discussion with him about this, and Florida is one of the more egregious of the states that conduct themselves in this way. So just for purposes of enhancing the record, Mr. Chairman, even though it's voluminous, perhaps we could do it this way. Just reference, I ask unanimous consent, that the record reflect the jail inmates Bureau of Justice Statistics by the U.S. Department of Justice, so that it could be anyone that wished to find this information rather than burdening the transcribers with having to put that much.
Without objection, and I thank the gentleman for bringing that to us.
That will work then, Mr. Chairman, and I won't burden either of our witnesses at this point with any further questions.
Gentleman, just back his time. Thank you very much. Distinguished gentleman from Alabama. Gentleman does not seek time. The gentlewoman from California does not seek time. Mr. Newhouse. Gentleman does not seek time. The gentleman from Freedom, Colorado.
Thank you, Mr. Chairman. I need to weigh in on this. I was a prosecutor for 25 years, Mr. Chairman. There are two factors that every court considers across this country, federal or state, whether an individual is a danger to the community, whether an individual is a flight risk. Those are the two factors. In deciding that, and I would be glad to, after this hearing, discuss this with my friend from Florida who had to make those evaluations. But in deciding that whether someone is released or not released, those are the two factors, not whether someone can pay bond. Only at the time that a court makes a finding that an individual is not qualified for a personal recognizance bond, will the court then set a money bond. Does it act unfairly? In some cases, absolutely. But without that money bond, what we're seeing in this country right now is a rise in crime. We are seeing a rise in crime because dangerous criminals are being put back on the street with either PR bonds or other restrictions on them, sometimes an ankle monitor or other things. And between the pretrial release and the parole programs in this country that are underfunded, that are largely ineffective, we are seeing an increase in crime. And the increase in crime is felt by the victims. It's not felt by us. It's felt by the victims. And those victims, unfortunately, don't have the voice that many of the liberal organizations that come in here and complain about the unfairness of these bond conditions have. And I feel for those victims of the crime. I dealt with those victims for 25 years, and I think it is time that we try to gather information as this bill helps us gather information to make the kinds of judgments we need to make about what are effective techniques to use for pretrial bond conditions and what, and frankly, what kinds of individuals are able to be released back into the community. It is a terribly important issue at a time of rising crime in this country. And I hope that we pass this bill, and I hope the Senate passes this bill, and I hope we get the kind of information we need to make sure that we don't have more victims in this country. I will.
One of the things that happens, and we can have the discussion afterward, just not to belabor it here, but the level of felony that you're speaking of and the exacting methodology to determine whether or not a person is released, I go along with that. But when you get to misdemeanors and folk that are held because of misdemeanors, if I were to use just one, driving recklessly, which is a bad thing. But that person that drove recklessly has no felony record, and then the bond is established and he or she doesn't have the money to pay. That's a different category. I agree with you about the rise in crime and the need to have the person return. But if a person just has a simple misdemeanor, as we are speaking in an hour in my community, we have for the last 3 years established a program for juveniles called Promise. And it has worked. We have seen the recidivism rate go down rather than run these kids through the jail system. And that's not the same subject, but a related matter that shows that you could release persons who have minor offenses and you're not involved with the criminal element that you're speaking about. They get lumped in. And if we dig deep into the statistics that I show you, you will find that those persons, the 65% of them in this country that are incarcerated during that particular statistical finding, you'll find that the great majority of them are Latino and African American people.
Reclaiming my time, Mr. Chairman, when I was a district attorney for 10 years in the Judicial District in Northern Colorado, we reduced the adult crime rate by 50%. We reduced the juvenile filings by 75%. That happened because we developed programs, many of them like the kinds of programs we're talking about here, that were effective, and they were based on information. We could not develop programs in the dark. We couldn't develop programs unless we knew what our goal was and who we were dealing with. And so we had a 97% success rate on our juvenile diversion program. In 5 years earlier, the county had done away with it because there was a 50% success rate. So we used statistics to achieve success. And all I'm suggesting is that the more information we get, the better off we'll be in developing good programs. I yield back.
Thank you very much. Is there any other member that would seek time? Gentlemen, I want to thank both of you. I think that every time we have members from the judiciary come up, it shows us how tightly woven so many of these programs are and their effect on other matters, and yet they do affect so much our communities and the future of youth in this country. And I appreciate and want to thank both of you for taking time to be here today. If you please remember that our awesome stenographer needs anything you brought in writing. Yes, sir.
I would like to bring out a point that we did in Pennsylvania. I don't know what's happening in other states in Florida and elsewhere, but I was a district attorney. I was a U.S. attorney, and we never let the fact that someone didn't have money determine whether they're in prison. As Mr. Buck so eloquently stated, are they a danger to themselves and to the community? And we've also gone to programs such as, for misdemeanors, such as ankle bracelets, reporting to to a parole officer or an officer of the court on a regular basis, bringing family members in and saying, look, we would like to send this young person home with you, but can you give us some assurance that you're going to keep an eye? And when the parents or a parent stands there, and like my mother who just passed, if she said, I'll make sure he's there, he's going to be there. That's the case. But also, as I mentioned, DUI courts, where people aren't going to jail for a misdemeanor. And these types of programs actually help them get on the right track and give them credit towards any time they might have had to do. Drug courts is a great example of that. So please, at least in my state and when I was a federal prosecutor, never in my mind was anything based on whether that individual had the money or not.
Well, if I just might, I practiced criminal defense law for over a decade, and while I appreciate the gentleman from Colorado and the gentleman from Pennsylvania describing their practice or their experience, I think they would acknowledge that there are thousands and thousands of people who are held in prison and in jails for an inability to post bail. People that somebody's made a determination that they could be released into the community safely if they post some surety bail, and they don't have the ability to post it. That's a fact. So there are lots of people who are poor, who are the only reason they're in prison is not because they've been determined to be unsafe or risk of non-appearing, but because they don't have $100 to post to or to give to a bondsman and post bail. That's a fact, and I think we ought to be working together to eliminate every single one of those cases, because in America, a presumptively innocent person shouldn't be imprisoned because they are too poor to afford posting bail. If we're in agreement on that, we ought to be taking up the bill that I referenced in my testimony that eliminates money bail. So only determinations based on risk of flight and danger to the community, and that no one will be held deprived of their liberty because of their poverty.
What other points that you are missing are the severity of the crime, the repetition of the crime, whether it's a felony or a misdemeanor. That's a factor that's involved as well.
In the dangerous determination and the likelihood to reappear. But I hope you will concede, and everyone didn't practice the way you do, that there are people who are in prison today who, but for $100 or $200, would have their freedom.
No, I'm not going to concede to that, because as I was in state court and as I was in federal court, that didn't apply.
Okay.
Anybody else?
Thank you, Mr. Chairman.
Well, I think this is perhaps Mr. McGovern's point that he tries to make. Judge Hastings does. Members on our side, Mr. Buck does. These are great debates for us. We do offer debates for this, and the committee is available to do that. I want to thank both of you very much and appreciate your time. Is there anyone else that would seek to be heard? HR 2152, HR 5645. Seeing none, this now closes the hearing portion, and Chairman will be in receipt of a motion from the distinguished gentleman from Oklahoma.
Mr. Chairman, I move the committee grant H.R. 5645, the standard merger and acquisition reviews through Equal Rules Act of 2018, a structured rule. The rule provides 1 hour of debate, equally divided and controlled by the chair and the ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule makes in order only the amendment printed in the Rules Committee report, if offered by the member designated in the report, which shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and unopponent, shall not be subject to amendment, and shall not be subject to demand division of the question. The rule provides one motion to recommit with or without instruction. Section 2 of the rule provides for consideration of H.R. 2152, the Citizens' Right to Know Act of 2017, under a closed rule. The rule provides 1 hour of debate, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of substitute recommended by the Committee on the Judiciary, now printed in the bill, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against other provisions of the bill as amended. The rule provides one motion to recommit with or without instruction. Section 3 of the rule provides for consideration of S.J. Res. 57, providing for congressional disapproval under Chapter 8 of Title 5 United States Code of the rules submitted by the Bureau of Consumer Financial Protection relating to the indirect auto lending and compliance with the Equal Credit Opportunity Act under a closed rule. The rule provides 1 hour of debate, equally divided and controlled by the chair and ranking minority member of the Committee on Financial Services. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. Finally, the rule provides one motion to commit.
Distinguished gentleman from Oklahoma has now presented the motion. This is one rule, 3 bills, H.R. 2152, H.R. 5645, and S.J. Res. 57. Is there an amendment or discussion to that? Gentleman from Massachusetts.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 5645 by Representative DeLauro of Connecticut, number 1, which would add a title to H.R. 5645 to include the Paycheck Fairness Act, which amends the Equal Pay Act of 1963. And if I could be heard just for a minute, as I mentioned when we began this hearing, that I was home over the recess, like all of you, and not one person asked me about any of the things that we were doing here today in this committee. Nobody brought up mergers and acquisitions or any of this other stuff. But I think we can all agree that it's about time we consider legislation to ensure equal pay for equal work. And since Republicans haven't brought a bill to the floor to address pay disparities, we ought to make this amendment in order, and we ought to have this debate. And so I urge my colleagues to vote yes on it and provide it the necessary waiver so that it can be made in order. I yield back.
Thank you very much. Further discussion? I would provide the information to the committee that bill as submitted was not germane to the bill of H.R. 5645. Further discussion? The gentleman's asking for an amendment to be made to the motion. Those in favor of the amendment from the gentleman from Massachusetts signify by saying aye.
Aye.
Those opposed, no. No. Noes have it.
Ask
Noes
for a
have
roll
it.
call,
Gentleman asks for a roll call vote. Clerk will poll the committee.
Mr. Cole? No. Mr. Cole? No. Mr. Woodall? Mr. Woodall? No. Mr. Burgess? Mr. Burgess? No. Mr. Collins? Mr. Byrne? Mr. Byrne? No. Mr. Newhouse? Mr. Newhouse? No. Mr. Buck? No. Mr. Buck? No. Ms. Cheney? Mr. McGovern?
Aye.
Mr. McGovern? Aye. Mr. Hastings? Aye. Mr. Hastings? Aye. Mr. Polis? Aye. Mr. Polis? Aye. Mrs. Torres? Mrs. Torres? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Could the gentleman please advise me how Mrs. Cheney is registered on this?
Mrs. Cheney is not recorded.
If the gentleman could please ask Mrs. Cheney if she has a decision on her vote.
Ms. Cheney? No. Ms. Cheney? No.
And if clerk could. The gentleman makes a good point. The question from the clerk was how Mrs. Cheney would wish to be recorded. The gentlewoman, I believe, has indicated that she's a no vote on the McGovern amendment. If the clerk will please provide that final tally.
4 yeas, 9 nays.
It is not
Excuse
agreed.
me, 8 nays.
8 nays. It is not agreed to. Further amendment or discussion? Gentlewoman is recognized.
I'm sorry, not further discussion. I have an amendment that I'd like to present.
Yes, ma'am.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order and give the necessary waivers for my amendment to H.R. 2152, number 3, which would add a new section to prohibit excessive fees on ankle monitoring bracelets associated with bail bonds.
Thank you very much. Discussion? Vote will now be on the Torres Amendment. Is there any, I'm sorry, those in favor signify by saying aye.
Aye.
Those opposed, no? No. Clerk, is any, no? It's not agreed to. Further amendment or discussion? Gentlewoman asks for roll call vote. Clerk will poll the committee.
Mr. Cole? No. Mr. Cole, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Collins? Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Mr. Buck? No. Mr. Buck, no. Ms. Cheney? Ms. Cheney, no. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Mr. Hastings, aye. Mr. Polis? Aye. Mr. Polis, aye. Mrs. Torres? Mrs. Torres, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
The amendment's not agreed to, not agreed to. Further amendment or discussion? Seeing none, the vote will now be on the motion from the distinguished gentleman from Oklahoma. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
Ayes have it, ayes have it. The gentleman has a roll call vote. Clerk will poll the committee.
Mr. Cole? Aye. Mr. Cole, aye. Mr. Woodall? Aye. Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Collins? Mr. Byrne? Mr. Byrne, aye. Mr. Newhouse? Mr. Newhouse, aye. Mr. Buck? Aye. Mr. Buck, aye. Ms. Cheney? Ms. Cheney, aye. Mr. McGovern?
No.
Mr. McGovern, no. Mr. Hastings? No. Mr. Hastings, no. Mr. Polis? No. Mr. Polis, no. Mrs. Torres? Mrs. Torres, no. Mr. Chairman?
Aye.
Mr. Chairman, aye. 8
Clerk
yeas,
report total.
4 nays.
The motion is agreed to. Accordingly, the gentleman, Mr. Buck from Freedom, Colorado, will be representing Republicans.
And Ms. Torres from California will represent the Democrats.
Ms. Torres will be representing Democrats. Okay, we are to the point now where the gentleman from Florida would like to ask a question. Gentleman's recognized. In fact, we have a meeting scheduled for tomorrow at 3:00 p.m., HR 3053. Thank you. Any other business for the committee? Seeing none, we've now completed our work for the day. Thank you very much.